I want to talk to you a little bit today about a recent case that I had with a client of mine named Ashley. Ashley was arrested for driving under the influence by the California Highway Patrol. She was actually stopped on the side of the freeway having a disagreement, and the CHP came on the scene and did what's called a welfare check. And they did an investigation to see why Ashley was stopped on the side of the road and to find out if everything was okay. During their investigation, they found out that Ashley had been drinking and that she was actually impaired for purposes of driving. They arrested her and took her back to the station, where she submitted to a chemical test, a breath test, with results of a 0.13, well over the legal limit. My office demanded a hearing in person, and I went down to the El Segundo Driver Safety Office to contest this administrative action against Ashley's license. So based on the lack of information, and in this case, the key piece of information that was missing was the time of driving. As I mentioned, Ashley was parked on the side of the freeway, and although she was impaired for purposes of driving, there was no way for the Department of Motor Vehicles to prove by a preponderance of the evidence at what time she drove and what her alcohol level was at the time of driving. So this is an example of a case where, although Ashley was impaired when the officers arrived on the scene, the department could not meet their burden and had to set aside or give Ashley back her driver's license. For a free, no-obligation consultation, please contact me and we can talk on the phone, or you can schedule an appointment to come into the office. You can reach me at 800-9700-DUI. That's 800-970-0384.